right, so bringing us up to the present, but borrowing and going all the way back to Ben Mushler and through Maurice's excellent presentations. Today, in my remarks, I hope to point out an important and often neglected concept, which I argue represents a sort of fundamental point of intersection between changing developments regarding privacy, national security, peace, war powers, and issues of free speech in wartime. And this concept is open diplomacy. Open diplomacy and its long historical context have been surprisingly absent in recent public square debates and discussions of such cases as the Manning trial, the advent and ramifications of Wikileaks, new revelations by Edward Snowden about NSA surveillance and the PRISM program, for instance, and the latest debates over war powers in Syria. So as my colleagues have so sort of astutely pointed out, and as the occasion of Constitution Day should help to remind us, I think longer-term historical perspectives and patterns are key to understanding these recent developments. So, what's open diplomacy? From the turn of the 19th century through the early 20th century, as the US rose to world power, both economic and military, policymakers began to debate the fundamental assertion that diplomacy should be conducted in the public gaze, within the purview of wider publics, domestic and later foreign. And they also thought that it should be pursued in the presence of representatives of all states, rather than be shrouded in secrecy and confined to those with a direct interest in its outcome. And here we begin to see, as early as the early 19th century, a kind of oppositional structure between public and private, between public and secret. Advocates of open diplomacy argued that the public should have free and unrestricted access to knowledge about government actions abroad and at home, and that there was a public reciprocal duty here, that the public should become informed about those activities, so that the public and the people would therefore be proactive in their own governance, proactive in their own foreign and domestic policies, and in the purview of the state. They should be proactive in uncovering new information about what the state is doing abroad and at home. So in turn then, Congress resolved to make American diplomacy more democratic. They aimed to inform the domestic public of what was going on abroad. Congress approved funding to publish annually what became a compendium of documents of diplomatic communications, and we have the whole series here at OSU, actually. Diplomatic communications, treaties, negotiations, and other documents known as Foreign Relations of the U.S. FRUST is what scholars of this call them. The series, prepared and issued by the State Department since 1861, is a compilation of selected documents from the files of the Department of State, the White House, and other agencies. It presents an historical view of American foreign policy and now comprises more than 450 volumes. It's absolutely voluminous. However, and this is where we get to the turn of the 20th century, national security, questions of war, questions of finance, limited resources impacted the publication of these documents, impacted the public diplomatic presentation of information to the American public. In the first decade of the 20th century, and then in the era of World War I, pressures related to cost and timing, as well as the exigencies of classification and national security, slowed this down. So at present, we're roughly declassifying documents from the 1970s. The latest publications are coming out from that era. The question of when and how diplomacy should be done openly and in public took on heightened significance in this era against the backdrop and the sort of formative moments of World War I. This was an era in which secret diplomacy was held largely responsible for the cataclysm of the war. If governments were to be democratically accountable in the domestic sphere, then it followed that they should be similarly accountable in the international sphere, where the scrutiny of a thinking and pacific public, and this empirical claim was axiomatic, that the scrutiny of a thinking and pacific public would prevent such dreadful events from ever happening again. And here we see the essential connection and ruptures at stake today, I would argue, in these debates. Generally open democratic politics seem to beget generally open diplomacy. If one falters, then the other falters. We could think here of the Espionage Act of 1917, which has gotten a fair amount of publicity in recent years. This sent scores of Americans to jail, such as the five-time socialist candidate for president, Eugene Debs, who spoke out against the constitutionality of the draft, in fact. And it permitted the widespread censoring of the mail and the press in wartime to prevent dissent, to prevent any impediments against the conflict. Ironically, and perhaps tragically, this is the same law by which Manning and others have recently been tried, as have 7 others in the Obama years. The act originally prohibited, quote, any attempt to interfere with military operations, to support US enemies during wartime, to promote insubordination in the military, or to interfere with military recruitment. And you can see how this amorphous language could be applied to virtually any disclosure of information in a wartime setting. In 1919, the US Supreme Court unanimously ruled in the Schenck v. US decision that the act did not violate the freedom of speech clause of the First Amendment, and therefore those could be convicted under its provisions had to stay in jail, even after the war. As Jeffrey Stone has shown in a brilliant book called Perilous Times, the constitutionality of the law, its relationship to free speech, and the meaning of the law's language have been contested in courts ever since, but haven't been overturned. And that's why the 1917 law is still being used against people like Manning, would be used against Snowden if he's ever extradited to the US, and others. And an important note, all the major prosecutions of the 20th century occurred under the aegis of this, right? Julius and Ethel Rosenberg, the Pentagon Papers, Daniel Ellsberg, and others. But so what did Wilson mean when he was talking about open diplomacy? What was this signal moment in the 20th century when open diplomacy was crucial? And how did it sort of jive with this deep sort of injunction against free speech? As Wilson, progressive journalist Walter Lippmann, and Wilson confidant Colonel Edward House put it as they explained his 14 points, the first of the 14 points was the essential one. This is what the New York Times is talking about on this slide that I put up. It's, quote, open covenants of peace openly arrived at, after which there shall be no private international understandings of any kind, but diplomacy shall proceed always frankly and in the public view. That's the key precept, according to Wilson. It was designed, they said, to, quote, clearly prohibit treaties, sections of treaties, or understandings that are secret, such as what the Triple Alliance had done in World War I. The phrase openly arrived at, they argued, need not cause difficulty. In fact, quote, the president explained to the Senate last winter, in 1918, that the phrase was not meant to exclude confidential diplomatic negotiations involving delicate matters. The intention is that nothing which occurs in the course of such confidential negotiations shall be binding unless it appears in the final covenant, which would then be made public to the world. It is proposed that in future every treaty, this is Wilson, Lippmann, and others making this case, that it's proposed that in future every treaty be part of the public law of the world. This is part of their cry for a League of Nations, for a fully fledged, functioning international body that pursued public diplomacy. That every treaty be part of the public law of the world, and that every nation assume a certain obligation in regard to its enforcement. Obviously, they argued, nations cannot assume obligations in matters of which they're ignorant, and therefore any secret treaty tends to undermine the solidity of the whole structure of international covenants, which it is proposed to erect. So, open diplomacy, when viewed in this way, can be quite practical. As an ideal, it also aims to give more of a hearing to small states, and this is another key component to this, and this is something that I think Americans and citizens of the world have been responding to in recent years. But the attack on secret diplomacy in the post-World War I era was often conceptually sloppy. It failed to distinguish among keeping secret the content of negotiations, keeping secret knowledge that negotiations are going on, the need for secrets in intelligence gathering, and keeping secret the content of any agreement issued from the negotiations. The most cogent attack was on this last point, on the so-called secret treaties and heinous state secrets that ought to be revealed to the international community. And these are really the pivot points on which I think today's debates over free speech, whistleblowing, and national security turn. Over time, more and more of the major decisions of the Cold War and into the 21st century have been the result of confidential sessions, even in the Security Council of the UN. Only by keeping discussion confidential, the argument goes, can deals be struck before being forestalled by those opponents to them, in principle, or by those opposed to the only terms on which they can be achieved. Open government is, therefore, within limits, an ideal American leaders and citizens, and arguably citizens of the world, have largely shared from the era of Madison and that first quote through the 20th century perspective of 1919 and beyond. Indeed, President Barack Obama endorsed just such a notion when he took office in 2009. Starting today, he said, he told cabinet secretaries and staff, Every agency and department should know that this administration stands on the side not of those who seek to withhold information, but those who seek to make it known. He then noted that there would have to be exceptions. He noted that the exceptions would include the protection of privacy and national security. And this is where the problems have occurred in the Obama administration have occurred. So let's consider the advent of WikiLeaks in 2007 and a few of the sort of key contours of dissident leakers like Edward Snowden and Chelsea Manning. At issue in these recent events, it seems to me, are vital elements of this longer history of what we've been describing from the 18th and the 19th century to the present, combining constitutional rights, interestingly, and what we hadn't yet heard about in the previous two talks: international law, international rights, human rights. Here we're talking about, generally speaking, the combination of the First, Fourth, and Fifth Amendment rights to free speech, to be secure in person and against unreasonable search and seizure, and for due process, with key articles from the Universal Declaration of Human Rights, which was ratified in 1948, enumerating such rights to which, quote, all human beings are inherently entitled. Here's 1925, when the 1000th treaty was registered with the League. Wilson's open diplomacy, this is the headline of the New York Times, open diplomacy was the ideal that was being recalled and heralded. And here we see Eleanor Roosevelt with the Universal Declaration in 48, and then just a few of the many types of classifications that are out there as of the early Cold War. Edward Snowden makes some similar claims to those of WikiLeaks, and I think I'll throw up a slide of what WikiLeaks claims are the international principles by which it derives its ability to publish secret and classified information. Edward Snowden makes very similar claims to these, to the building on a shared commitment of international law to assert broader principles, such as enumerated above. When Snowden met with representatives of human rights organizations on July 12, 2013, he blended his domestic constitutional rights as a citizen with the lofty aims of a whistleblower form of open diplomacy. And he also argued on the basis of UN-guaranteed rights. As he put it, and as reported in the Daily Telegraph, the Fourth and Fifth Amendments of the Constitution of my country, Article 12 of the Universal Declaration of Human Rights, and numerous statutes and treaties forbid such systems of massive pervasive surveillance. While the US Constitution marks these programs as illegal, my government argues that secret court rulings, which the world is not permitted to see, echoing back to the questions I was just talking about earlier under Wilson, somehow legitimize an illegal affair. I believe in the principle declared at Nuremberg, said Snowden, individuals have international duties which transcend the national obligations of obedience. Therefore, individual citizens have the duty to violate domestic laws to prevent crimes and future crimes against peace and humanity from occurring. Recently, in an opinion just released last Friday by the Foreign Intelligence Surveillance Court that oversees the NSA, Judge Dennis Saylor wrote that the court should in fact make more of its rulings public. So some of the response to this is exactly what Snowden and Manning hoped for. In response to the public's demand for greater transparency around foreign and domestic surveillance issues following the Snowden leaks. And Forbes reported just a few days ago, apart from Saylor's remarks, that the Director of National Intelligence, James Clapper, separately told a Washington conference that, quote, it's clear that some of the conversations Snowden's leaks have precipitated generated debate actually needed to happen. So even people within the national security establishment have recognized that these leaks have generated important debates. Chelsea Manning, as we know, attempted to assert similar rights to those claimed by Snowden and WikiLeaks as part of an ethical commitment as a whistleblower, disseminating such disturbing and important images as the infamous collateral damage video. This is one of an American helicopter pilot getting legitimate authorization to attack a group of people who turn out to have been, some of them were Reuters newspaper reporters, among others. But the prosecution of Manning pressed on with a dozen more serious offenses even after Manning admitted that that was a, quote, unauthorized possession of improper storage of classified material. And again, what's interesting here is that the prosecution here takes the 1917 Espionage Act as the key foundational ideal, and that this is very similar to what Richard Nixon attempted to retool as he opposed Daniel Ellsberg in the case against the Pentagon Papers, which we could go on with, but Obviously, we don't have time for that now. Hopefully, we can talk about it. Judge Denise Lind announced in the Manning verdict an acquittal of the soldier of aiding the enemy, but convicted Manning on Espionage Act charges. And this is the first time that that went all the way through. It's the first court rendering of a decision in this way on that decision. And President Obama, who taught constitutional law and repeatedly has professed the importance of transparency and of ethical whistleblowing, has overseen during his administration a record 8 prosecutions based on the Espionage Act, more than all presidents since Wilson combined. And they only pursued 3 such cases between 1921 and 2003. These responses in recent years are thus reminiscent of the World War I era, 1917 to 1920, free speech debates and deportations of ensuing individuals under the Red Scare, and they also echoed debates over the Pentagon Papers and others. But this is not a simple issue of right and wrong, of rights and laws. While public debates have and continue to ratchet up tensions by falsely pitting national security and patriotism on the one hand against sort of free speech and the ethics of whistleblowing on the other, the problem is far more nuanced, and it goes back to this Wilsonian moment, and maybe back to the founders as well, in thinking about how should diplomacy be conducted, how should national security and intelligence be gathered and protected. What are the limits of free speech, given some legitimate concerns of national security and the practical issues of putting individuals, groups, and methods in harm's way? What might leaking be most effective and most ethical? In what cases and when and where? What are the duties of those empowered to share what they know? And ultimately, should governance and diplomacy be more or less open? And who gets to decide? Many intellectuals and groups, and I think many here will want to discuss this, including the ACLU, have labored hard to draw casuistic distinctions, as Chase Madara has recently argued in The Nation, between what they see as Snowden and Manning's irresponsible leaking and Ellsberg's virtuous leaking, such as the Pentagon Papers. These exercises sort of zealously avoid the main legal difference. The thousands of documents leaked by Ellsberg were uniformly classified top secret. The thousands of documents leaked by Manning were not. Snowden, right in the middle. Some were, some weren't. Meanwhile, Ellsberg himself has been a tireless defender of Manning and Snowden. All right, so one last point, and I have some prescriptions, but I think I'll leave them for our discussion. A turn to the history of open diplomacy then reveals the contours and complexities of the challenges of the past that confront us in the present. There are no easy answers here. Even when taken on an ad hoc basis, there are clearly problems with Americans taking it upon themselves as individuals to decide when, where, and why to police the state, to blow the whistle on government actions, be they good, bad, or indifferent. Nevertheless, whistleblowers, leakers, patriots, traitors, heroes, dupes, sources, informants, and most recently, the newest term for this, dissidents, which harkens back to other forms of opposing totalitarian regimes, whatever you choose to call them, are essentially getting information to the public. And this is back to that Madisonian point, right? If you don't have these individuals gathering this information, if you don't have a public taking proactive action, where do you go? How do you move forward? They have been in the past, they're likely to be in the future, and the perennial debate over how the limits of free speech, of questions of privacy, and of how much information to reveal to the public about diplomacy, war and peace, is a healthy one. And I would argue, just sort of in conclusion, recent prosecutions under the 1917 Espionage Act are disturbing to say the very least. And I'm hopeful that in our discussion, we'll tackle some of these important issues.